Friday, August 2nd, Robert Kraychik reporting for Rebel News in Lethbridge, Alberta. Jurors reached their verdicts for the charges against the two men late at night after deliberating for about 2 days and a bit. The two men were found not guilty of the most severe charge they both faced, conspiracy to murder. Specifically, the Crown had accused the two men of conspiring to murder police officers during their time and participation in the 2022 Coutts protest and blockade. The two men were found guilty of all other charges against them. Both Carbert and Olenek were found guilty of unlawful possession of a firearm for a dangerous purpose and mischief over $5,000. Olenek was additionally found guilty of unlawful possession of an explosive device. The 2022 Coutts protest and blockade, much like its sister demonstration in Ottawa, Ontario, the Freedom Convoy, was a peaceful and civilly disobedient protest against this governmental apparatus of surveillance and control and censorship, this so-called public health apparatus with edicts and mandates and orders ostensibly issued to reduce COVID-19 transmission. One of the most newsworthy occurrences that took place during proceedings that were subjected to a publication ban was the attempt by the Crown to introduce as an expert witness a woman named Barbara Perry. So who is Barbara Perry? I'm glad you asked. She's a professor at Ontario Tech University in Oshawa. She is the director of the Center on Hate, Bias, and Extremism. She works for the Faculty of Social Science and Humanities, and her little blurb on her profile indicates that she is a, quote, global hate crime expert and leading author. All sorts of expert witnesses are qualified in all sorts of criminal trials in this country, and this is not a new thing. You can introduce a medical expert and qualify him or her to testify about certain things that layperson jurors otherwise would not understand. You could have a firearms expert. You could have some sort of engineering expert. In this case, it's newsworthy and novel given that Barbara Perry's ostensible expertise in hate crime would have opened up a new avenue of expertise in Canadian criminal trials if she would have been qualified as such. Now, spoiler alert, she was not qualified. Justice David Labrenz, the judge overseeing this trial, during these pretrial disputes between the prosecution and defense teams, arguing over the rules of the game, rejected the Crown's attempt to qualify her and introduce her as an expert witness to speak to jurors. If Barbara Perry would have been qualified as an expert witness, as the Crown requested by Justice David Labrenz, it would have created a new precedent going forward across Canadian criminal trials in which these sorts of experts, those who are ostensibly experts in ideology and politics and hate crimes and Islamophobia and white pride and right-wing extremism, could now be introduced going forward to advise or inform jurors of what they perceive as the ideological or political or philosophical frameworks of defendants. To give you a sense of flavor of this Barbara Perry woman's perspective in terms of politics, philosophy, and ideology, and her ostensible academic angle, I want to read some titles for you folks of speaking engagements that she did in 2015. And they're all like this, by the way. Quote, White Pride Worldwide. Constructing Global Identities Online. Another, Identifying and Responding to Right-Wing Extremism. Another one, Right-Wing Extremism in Canada. An environmental scan of the current state of the Canadian movement. Another, Missing Pieces and Misplaced Priorities, an acknowledgement of right-wing extremism in Canada. Clearly, so-called right-wing extremism, whatever that is Barbara Perry's focus. And the Crown sought to introduce her as an expert witness to guide jurors in terms of understanding what the prosecution would allege was the mindset and ideological framework of Chris Carbert and Anthony Olenek. Some interesting case law was established during pretrial proceedings, which I can now report on given that the publication ban on these proceedings has expired. During its ostensible investigation of criminality at the 2022 Coutts protest and blockade, the RCMP utilized so-called imminent harm search warrant authorization. Normally, when a law enforcement agency seeks to obtain a search warrant, either to search a business, a car, or in this case, to intercept digital communications, phone calls and text messages, the law enforcement agency must meet with a judge and make its case as to why it has reasonable grounds to have this search warrant authorized. In the case of imminent harm, a law enforcement agency can authorize such a search warrant request for itself without meeting a judge. And the justification for this type of so-called imminent harm authorization is that there is such an emergency, there is such an urgency to execute this search warrant that the law enforcement agency does not have the time to meet with the judge and make its case to get this search warrant authorized. The RCMP did that at Coutts. The RCMP intercepted phone calls and text messages from all sorts of individuals who were protesting there, including the defendants, with the justification that there was an imminent harm, there was a threat of danger to police officers. This search warrant authorization of digital communication intercepts lasted 72 hours. I'll allow the audience to consider for themselves whether or not 72 hours of surveillance constitutes imminence. How imminent was that? Now, this establishes case law going forward. Why? Because this search warrant authorization, the evidence obtained from it, the interceptions of text messages and phone calls, was sought to be introduced into this trial as evidence by the Crown. The defense teams objected to that during pretrial proceedings. And Justice David Labrenz, the judge overseeing this trial, threw out 48 of the 72 hours of intercepts. In other words, he allowed for the first 24 hours of intercepts, phone calls, text messages, to be authorized as evidence in this trial. That sets a new precedent going forward across all Canadian criminal trials for this sort of authorization, this imminent harm authorization of a search warrant. There's no other news media outlet out there that can claim, as we at Rebel News do, that we've been on top of these stories since day one, since their inception, their genesis, their origin. We had reporters embedded on location at the 2022 Coutts protest and blockade, creating unparalleled, original, top quality journalism. I hope I'm carrying that torch, because here we are, fast forward to August 2024, and we're still deeply invested in reporting on the trials that flew from these prosecutions related to the 2022 Coutts protest and blockade. And of course, this sort of original journalism carries with it operational costs. On top of that, obviously we're not getting handouts from the federal government to toe that official narrative and line from the broader machine. And that's where our beloved Rebel News audience comes in. Please contribute, please donate so we can maintain this journalistic enterprise. Visit truckertrials.com, donate, stay up to date with our ongoing coverage.